sorry to disappoint you at the very beginning. I'm going to be much longer than Maya. Okay, speakers before me, I wish to thank to the organizers for inviting me and to giving me this opportunity. As announced, the title of my presentation is the Organization for Security and Cooperation in Europe, a political vanguard of... I lost. Yeah. Okay. A political vanguard. Thanks. A political vanguard of the international rule of law. I guess you noticed that among all topics presented at this conference, this one is the least attractive, I would say. But anyway, essentially, my presentation is a summary of my monograph chapter, and I will explore as much as I can in less than 20 minutes how the rule of law is understood by the OSCE, and following the format of the book chapter and of the book as such, I will also address control mechanisms and sanctions. My presentation is based on the assumption that among international organizations, OSCE is actually in a deep shadow if compared with other organizations, and also that probably most of us is much less familiar with this organization than with other organizations. And before I start, I would also like to apologize for two things. My slides are, you see, there are way too much. There is way too much text. It is meant just to assist me, because I'm not as operative in English as in Slovenian, of course. And I will provide for the very beginning some general information on OSCE. It was established in 1975 as a result of the Helsinki Final Act. This was signed by 35 countries, but back then it was named differently, namely the Conference on Security and Cooperation in Europe. And as a newly founded regional security organization, OSCE aimed to prevent conflicts among participating states by addressing issues related not only to security but broader to human rights and democracy. And over the years, OSCE has expanded the structure and activities and now serves as a platform for dialogue and cooperation among its participating states, which are from Europe, Asia, and North America. And the underlying principle of functioning of OSCE is cooperative security. And the idea behind it is that cooperation of all states shall guarantee security, peace, and stability. The OSCE's approach to security is obviously multi-dimensional approach, encompassing several areas and issues such as conflict prevention and resolution, arms control, democratization, rule of law and human rights, as well as economic and environmental security. You will see that OSCE has a very unique organizational structure, which includes the main political body, the main decision-making and governing body, the main body for day-to-day decision-making and coordination, as well as several autonomous institutions which support OSCE activities and carry out the so-called field operations to assist countries. And the decision by the OSCE bodies are politically binding, of course, and they are adopted by consensus by the states. And since all states enjoy or should enjoy equal status, these decisions must or should reflect their agreed views. And you will see that OSCE addresses the rule of law as a cornerstone of its human rights and democratization activities. Looking briefly to the organization and the structure of the OSCE, a little bit closer, I would say that OSCE operates with a complex but light structure. It has this summit of heads and state government. This is a strategic body. Actually, they provide orientation, priorities, but all the relevant documents of the OSCE were adopted by this summit, like Helsinki Act and also Paris Charter, Budapest document, etc. A ministerial council, it's a central decision-making and governing governing body. It consists of foreign ministers, but at some sessions also other ministers can sit, and they sit in annual meetings, and they bring this OSCE final documents, and that's actually the place where you can find out what is the stance of the OSCE on the rule of law. Then this permanent council is also, this is for day-to-day decision-making body sitting in Vienna, but it's also important because it may convene special meetings in order to discuss matters of non-compliance with OSCE commitments and to decide on appropriate courses of action. I will get back to this permanent council when I will be talking about control mechanisms. Also, I would like to draw your attention to the Parliamentary Assembly, because it's actually the only body composed of members of parliaments, not of members or representatives of executive branch. But the problem with the Parliamentary Assembly is, according to my understanding, that its status is not entirely clear. Rules of procedure of the OSCE do not place it among OSCE decision-making bodies, but among other structures and institutions. But according to my knowledge, parliaments or parliamentary assemblies supposed to be decision-making bodies, right? But anyway, so among executive structures of the OSCE, I would like to draw your attention to the well-known Office for Democratic Institutions and Human Rights. This is the most important executive body in the field of human rights and the rule of law, and it provides support to OSCE bodies and institutions, as well as assistance and expertise to participating states and civil society. Among OSCE-related bodies, I would just like to draw your attention to the Court of Conciliation and Arbitration. It's actually an interesting mechanism for the peaceful settlement of disputes, not among OSCE bodies and states, but among states. And I will get back to it as well when I will be talking about control mechanisms. The thing which is particularly important regarding the OSCE's understanding of the rule of law is this notion of human dimension. The term concerns a large number of political binding commitments relating to what has become known as human dimension of the OSCE's comprehensive security concept, and as it is used today, the term is related to human rights and fundamental freedoms, democracy, including democratic elections and democratic governance and institutions, tolerance and non-discrimination, and the rule of law, as well as national minorities, human contacts, and international humanitarian law. There were certain conferences at the end of 80s, beginning of 90s, which can be seen as the codification of the human dimension in the post-Cold War forum. And since then, the main focus was, or has been, on putting it into force, or into practice, better to say. And throughout the decades, indeed, the OSCE has been trying to further develop its commitments under this human dimension, considering it a cornerstone of lasting peace and security in Europe. And to make long story short about this human condition, in connection with these commitments, the notion, I would say a rather optimistic one, emerged that OSCE is not simply an organization of participating states, but a community of values, meaning that in essence, OSCE states have agreed through their human dimension commitments that pluralist democracy based on the rule of law, basically understood as a concept of protecting the dignity of the human person through laws and legal structures, is the only system of government suitable to guarantee human rights effectively. To address the core of my presentation, the rule of law is understood and contextualized by the OSCE. It is referred to in one way or another in almost all documents adopted by the main OSCE decision-making bodies, and it's really a bulk of material. In my book chapter, the specific areas and issues pertaining to the human dimension commitments were identified and identified, indicating how the rule of law is understood and contextualized by OSCE decision-making bodies, and these areas and issues are general principles and aspects of the rule of law, independent and impartial operation of the public judicial service and independent legal practitioners, lawful operation of the law enforcement agencies, fulfillment of international obligations, protection of national minorities' rights and civil society, economic liberty, social justice and environmental responsibility, fight against corruptions and all other kinds of fights against terrorism, violent extremism, organized crime, drug trafficking, and so on and so on. So to put together all this really huge material, I would say that references to the rule of law in the OSCE documents and decisions are very general by its nature, and as such, I would say that they do not inspire all this discussion about different approaches to and different interpretations of the notion of the rule of law, which we saw at this conference emerges in other international or supranational organizations. It is understood and contextualized by decision-making and executive bodies in quite a similar way as by other international organizations. And it implies general provisions and aspects which are characteristic of both the concept of the rule of law, which was formed in the constitutional traditions of European countries, of course, as well as of the international and supranational version of the concept promoted by the international and supranational organizations. But interestingly, regarding the case law of the international courts, it's been said a lot about the case law throughout this conference. In the OSCE documents and decisions, there is no direct references to it whatsoever. Regarding the OSCE understanding of the rule of law, it is essential to understand that it is essential for ensuring respect for all human rights and fundamental freedoms, meaning that the independence between the rule of law and human rights is particularly emphasized. It guarantees this understanding of the rule of law by the OSCE, guarantees equal human rights and status for all citizens, the free expression of all their legitimate interests and aspirations, political pluralism, social tolerance. It, of course, also implies the implementation of legal rules that place effective restraints on the abuse of governmental power, meaning that it implies that all action by public authorities must be consistent with legal rules that guarantee, thus guaranteeing legal security for the individuals. Also, it aims at building a climate of mutual respect, understanding, cooperation and solidarity among persons living in the OSCE states without distinction to ethnic or national origin or religion. It also relates to the transparency of and confidence in public institutions, women's equal participation and representation, and the inherent dignity of the individual. In addition, the rule of law, as understood by the OSCE, is inseparably connected with what has already been mentioned, independent and impartial operation of the judicial services, lawful operations of the law enforcement agencies, fulfillment of international obligations towards other international organizations, political protection of national minorities' rights and civil society, economic liberty, social justice and environmental responsibility, and effective all kinds of fights, as I said before. All in all, I would say, look, all the good things of this world are somehow, captured in this concept of the rule of law as understood and contextualized by the OSCE as a political organization. I will just skip now this more precise demonstration of how the OSCE understands the rule of law in the context of general or through the general principles and aspects of the rule of law and in the context of independent and impartial operation of the public judicial service. I will just move to the control mechanisms. They are quite unique, I would say. They differ quite significantly, actually, from those established within other international or supranational organizations. OSCE decision-making processes, as was emphasized, fundamentally a political endeavor, so it does not establish legally enforceable norms or principles. In other words, OSCE documents and decisions on human dimension commitments are politically binding rather than legally so, and this means that these commitments by the states is not controlled or are not controlled and cannot be enforced by a court of law. But this should not be misunderstood. They still are obligatory, they are binding, they are politically binding, and in practice it means that states cannot invoke the non-intervention principle. This, I think, is important. So they cannot invoke, as I said, the non-intervention principle to avoid discussions about human rights and related issues such as the rule of law within their countries. And indeed, the OSCE created a set of procedures, conferences, bodies that help to monitor and assist with the implementation of human rights dimensions, human rights commitments. These are parliamentary assemblies, promotion of the respect for the rule of law, then monitoring and reporting on human rights issues, particularly by the Office for Democratic Institutions and Human Rights, then other OSCE institutions, field operations, and last but not least, also participating states' ongoing and envisaged bilateral activities regarding the rule of law. But most importantly, and this is a little bit more formal, I would say, the states established a preparatory committee, which I mentioned at the beginning when I was talking about the structure, under the direction of the Permanent Council, and task by the Council. This preparatory committee normally meet in informal format and brings together, on the one side, representatives of the OSCE and the representatives of the OSCE and the states concerned on the other side, and in order to address questions regarding competence with OSCE commitments. But normally these deliberations of this preparatory committee on the matters regarding compliance take place in review meetings or conferences or even in economic forum, and such matters are then submitted for considerations by the Permanent Council, but not on the basis of this preparatory committee itself, but on the basis of the facts found by personal representatives of the chairman in person. This is the official managing ministerial council, or recommendations by OSCE institutions. And then the Permanent Council meets in special format in order to discuss these matters of non-compliance and to decide on the appropriate courses of action. I will be very honest, I did not couldn't find out how many such proceedings have been carried out so far and whether they address the rule of law issues in particular. This is something which will still have to be discovered by myself. Finally, sanctions. The OSCE documents do not explicitly define any consequences or sanctions for cases of non-compliance. This seems to reflect the key characteristics of the OSCE as a primary political organization, as well as the nature of its control and implementation mechanisms, which I was talking about. Rather than imposing sanctions, the OSCE relies on soft mechanisms, such as discussing with states matters of non-compliance and searching for appropriate solutions, promoting the rule of law by providing expertise, political guidance, and assistance, developing training programs and organizing capacity building events, establishing field operations and at aimed at strengthening human rights, democracy, and the rule of law standards and practices. To conclude, I would say that by adopting the Paris Charter of 1990, the OSCE states have recognized democracy and the rule of law as the only legitimate principles of governance within the OSCE area. With this, the states have directly linked the quality of interstate order to their ability to organize internal sovereignty along liberal democratic lines. Finally, and most importantly, although this consensus has opened the door for constructive intervention within the system of each state, by political means, of course, the state sovereignty stays untouched, as OSCE bodies cannot enforce actions against the will of a state. Thank you very much.